Ladies and gentlemen, today I would be giving a brief view or bird's-eye view of what's the trend of trend of the Indian courts or Indian judiciary in dealing with IP case laws, especially in the frontier of telecommunications. Even before I start with the actual IP cases or the Indian cases, I would like to give a brief background as to what is all about SEPs. See, the moment when we speak about telecommunications, primarily it's nothing but litigation in relation to SEPs. SEP is nothing but standard essential patents, which means that the patents covers certain technologies which are considered as an essential technology in that particular industry. There are quite a few types of SEPs, and they are like, first, for example, de facto standards or the de facto patents, wherein the standards would have been adopted by a particular industry without any prior existing arrangements, like, it could not be an agreement or it could not be any intentional cooperation or something like that. The second one is de jure standards, where the government or the statutory body or an organization would impose a particular standard on a particular industry. When we speak about telecommunications, the last one is the most essential one, where the standard setting organizations would have come out with the particular standards, and those standards may have thousands of patents. So those patents which sits in the standards set by the standard setting organizations are primarily called as standard essential patents. Usually, when a patent holder has a patent in relation to telecommunications, and if that patent is supposed to be sitting in the standards, that means to say that he has to give a declaration stating that his patent is an essential patent to perform a particular aspect in a particular technology. For example, the technology could be a CDMA or CDMA 2000, wherein when you're communicating or when two devices are interacting with each other, the platform on which it interacts, it could be an SMS, you're sending a text. So that text involves certain patent, and if that patent is sitting in the standard, then that patent is a standard essential patent. So likewise, it is also essential that the patent holder, while declaring that his patent is a standard essential patent, he should declare that he is willing to license for any person on something called as FRAN terms, which is fair, reasonable, and non-discretionary terms. In US, it's popular as RAN terms. So the moment he declares that his patent is an essential patent and he is willing to license, and if those patents sit in the standards, then it's deemed to be a standard essential patent. Often, it's seen that due to the issues of interoperability and technological convergence, there are certain issues which have emerged in licensing terms, or in terms of infringements, or in terms of convergence of technologies. So these issues have led for various disputes, including patent infringement disputes. Today, I will be just discussing about 5 case laws. That is Ericsson Micromax, Vringo ZTE. Again, there are 2 cases filed by Vringo against ZTE. That's one is CDMA, another one is GSM. And Ericsson Xiaomi, which is about AMR patent. And Vringo Asus. And this is again, Vringo Asus is a software prediction software. Or this particular prediction software is upon a device wherein it, the moment when you key in your device, the device creates a dictionary in your phone, so that the moment when you are again using the same thing, it predicts from your device and then it passes on. Now coming to Ericsson Micromax. This is, I would say, this case, in fact, opened the gates for telecommunication litigations in India. Essentially, an action was filed, or it was brought by Ericsson against Micromax, alleging that Micromax was indeed using several patents which were termed to be, or which were considered to be, a standard essential patent, which include the GSM technology, the edge technology, and the AMR and WCDMA technology. So basically, the primary contention of Ericsson was that Micromax was essentially using 8 of its standard essential patents without its consent, without the license, and hence there was an infringement by Micromax. Delhi High Court passed an ex parte ad interim injunction where Micromax was literally stopped from conducting its business in India. So Micromax, again, they approached back the Delhi High Court, wherein it was a consent order was passed and the ex parte injunction was modified and interim royalty arrangement was fixed. I would not go into the details as to what was the price and figures and all. Subsequent to the consent order being passed and interim royalty being fixed, the matter was referred to mediation. And now these days, in the most of the matters, I would say 90% of the matters before the court are referred to the mediation because of the ADR regime in the Indian judiciary as of now. So the matter was referred to the mediation, where the mediation talks failed. And in the meanwhile, Micromax had already challenged the order of its own consent order. So parallelly, Micromax, it approached the CCI complaining the abuse of dominant position by Ericsson in demanding unreasonable royalty rates. The CCI further, it just went ahead and then said that it opined that Ericsson was indeed abusing its dominant position, and hence it ordered for an inquiry by the Director General of CCI. Then further on, this order of CCI was challenged by Ericsson before the Delhi High Court, where Delhi High Court said CCI cannot interfere with patent litigation or patent infringement suits. But however, it did not interfere with CCI's orders of investigation. And it said that CCI or DG can proceed forward and in investigating the matter for abuse of dominant position. So then later on, in its appeal, the Micromax appeal, which was still pending, in that appeal, the divisional bench revised the entire interim arrangements. So now there are various things happening around in Micromax matter. You have your single bench, which was a consent order. Then that consent order was challenged. Parallelly, a CCI competition complaint was also being filed. So now here, then later on, divisional bench gave an ending for all such kind of confusions, and it said that based on the royalty rates fixed by Ericsson in various other transactions over the same patents, there should be an interim royalty being fixed on the similar lines. And based on those existing agreements, an interim royalty was fixed. So this is, as of now, there is an interim royalty which is operating for the year 2014-15, and likewise there is a yearly increase in the interim royalties. The next matter is about Vringo and ZTE. I would be taking about ZTE, CDMA and GSM patent matters together. The reason being that it's on both on a similar thing. The only issue is the technology is different. That's it. So initially, what happened was Vringo filed a patent infringement suit against ZTE in both these CDMA and GSM technologies, wherein literally ZTE's operations were stopped due to the issuance of the ex parte injunction order by the Delhi High Court. So then later on, ZTE did not approach the single bench which had passed an ex parte injunction order, but it appealed and succeeded in that appeal before the divisional bench, saying that the usage by ZTE would not cause any irreparable loss or injury for Vringo. And hence, the usage, it cannot be stopped from using, if at all it's using the, all the patents which are involved, if at all it's using it and if it's held to be using, and that particular use can be compensated in terms of money. And hence, based on this, the injunction was vacated. And further on, a bank guarantee was supposed to be deposited by ZTE, saying that in an event it was held to be infringing, then the loss can be made good by the bank guarantee. And also subsequent, like in the consequential orders saying that accounts of profit has to be deposited, quarterly accounts, and then the customs were ordered or directed to stop or to intimate Vringo about ZTE shipments. In both the GSM and CDMA technology, the similar kind of order has been passed. In Ericsson's Xiaomi matter, again, Ericsson filed an infringement action against Xiaomi, wherein Xiaomi, an ex parte injunction was passed and Xiaomi's operations were stopped. Xiaomi appealed on this ex parte injunction order, wherein the division bench was of the opinion that there should be an interim royalty arrangement should be made, and that interim royalty arrangement was on a different note, and it was now about 100 rupees per device, wherein if at all, if Xiaomi is using a particular chipsets, and that is Qualcomm chipsets. So this is the other one. And the last one is about Vringo Asus, where virtually no order whatsoever was passed against Asus. And Asus is now not even obligated to deposit any kind of bank guarantee. So basically, what the Ericsson Micromax, you have a very strict order. This is about in the year 2013. A strict order of interim royalty being fixed, which has to be followed. And then you have your Vringo ZTE, series of cases, wherein you're free to use the the patents, unless and until you deposit certain bank guarantee. So all you have to do is you deposit a bank guarantee as surety, saying the reason why you have surety is because in an event if you are held to be infringing the patent, then that infringement can be made good by payment of this particular bank guarantee. And then you have Xiaomi, where altogether a different royalty calculation was made, and then it said that if you are using a particular kind of chipsets, and those chipsets, you have to deposit this amount of money. If you're not using, then you're free to use it. And then lastly, you have your Asus matter, wherein it was held that if at all your loss can be made good by payment, by way of payment of some damages, then an ex parte injunction or a temporary injunction cannot be granted. So basically, when we critically analyze all these case laws which are there as of now, the common element which can be seen is that the patent holders, even before litigation, they would be approaching the the potential defendant or the potential infringer or the alleged infringer, and these pre-litigation talks fails. Because of these failure of pre-litigation talks, instead of having a different approach, they would directly approach the courts in the guise of patent infringement suits, and then try to take an interim relief. It's kind of arm twisting tactics. The reason why I'm saying this is because the courts, especially when it comes to SEP matters, the courts would not see that whether the defendant is actually infusing the particular patent or not. It's virtually like my patent, I have declared it to be a standard essential patent, and it's sitting in one of the guidelines or one of the standards of for example CDMA, and hence if the defendant's products are compliant of CDMA technology, then it's infringing. So there's no interaction, there's no analysis as to whether this particular defendant is actually using his patent or not. So this is one of the key factors for which has been the courts have now been considering, especially in the Asus matter, and then the court refused to pass an ex parte additive injunction. And then secondly is that in Micromax matter, the courts did not appreciate that the loss or the injury suffered by Ericsson because of usage of the patent by Micromax can be compensated in terms of money or damages. And that's the main reason why ex parte injunction in Ericsson matter survived for some time. And then later on, the divisional bench, it actually revised the interim royalty arrangements and lift up the injunction. So what we are trying to see here is, you had your strict, judiciary where it said that if at all if I'm satisfied that if the plaintiff is suffering irreparable loss and injury, then an injunction can be passed. Now it's not so. Now another major factor is time and again I was saying that I declare it to be an essential patent as a patent holder. There is no criteria for any organizations or SSOs to say that yes, or to certify that a particular patent is a standard essential patent or not. It's because of this small issue, various things have cropped up, and then later on you have matters ending up in the courts to say that, okay, my patent is a standard essential patent and your products are compliant with this particular technology, and indirectly that means to say that you are using my patent. So with this note, I would conclude my presentation. Thank you.